Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're discussing the federal government's invocation and later retraction of the Emergencies Act, a piece of extraordinary legislation only available in very specific circumstances that gives the government special powers, like the ability to create new criminal offenses and police powers without recourse to Parliament, advance notice, or public debate. The federal government invoked this legislation to address the truck protests in Ottawa, despite the fact that protests at border crossings and bridges were dealt with using ordinary police powers. This legislation has never been used before in Canada's history, and civil liberties organizations have expressed concern. The charity I work for, the Canadian Constitution Foundation, is taking the federal government to court over their decision to invoke this extraordinary legislation. Here today to talk about the case are the two lawyers representing the CCF, Sujit Chowdhury and Janani Shanmuganathan. Thank you both so much for joining us today. Let's start with the basics. Sujit, the CCF has filed a legal challenge to the federal government's use of the Emergencies Act. Why?
And so the Emergencies Act is an extraordinary piece of legislation because when it's triggered by the federal government, it effectively amounts as a temporary amendment to the Constitution, and in two big ways. The first is that it delegates vast lawmaking power to the federal cabinet that would normally have to be exercised by Parliament as a whole, and in this context, where there is now a Senate that operates at times quite independently of the House, a bicameral process. With committees and debate, and the federal cabinet can do things instantly without any of that process. So, for example, creating a crime and attaching penalties to it. And secondly, the act allows the federal cabinet to enact such law-like measures in areas of provincial jurisdiction. And so, without the Emergencies Act, the federal cabinet can't do either thing. And so it's really important that this extraordinary power be exercised very narrowly and very carefully within the tight confines built into the legislation itself.
Janani, sort of same question. What's your take on the importance of this case?
So this is the first time that this Emergencies Act has been used. And I think we as Canadians want to ensure that when Parliament invokes such an extraordinary piece of legislation, that they're doing it for the right reasons and they met the right requirements. So this is going to be a really important case for us to see what kind of guidance is going to be provided in future cases so that if this was a mistake, we'll learn from those mistakes.
So, Janani, I want to go over briefly some of the powers that the government gave itself under those emergency orders. What were they? What did they empower themselves to do specifically when they invoked the Emergencies Act?
So there's two sets of regulations that came about as a result of resorting to the Emergencies Act. So the first is Emergencies Regulation, and those powers have to do with public assembly. They've essentially made it so that you cannot go to a public assembly if it could reasonably lead to a breach of the peace. And we'll come back to the question of what does that even mean. And the second set of regulations that they've invoked has to do with economic regulations. So they have to do with banks who have information about our bank accounts and requiring those banks to provide that information to the police or to financial institutions if they think that it's suspicious transactions in relation to those public assemblies.
Now, Sujit, the federal government said they needed these powers in order to deal with the protests, but we argue that that isn't true. They could have used ordinary police powers. So can you elaborate on that a little bit?
Right. So, the Emergencies Act sets out four different categories of emergencies, and the emergency that was declared by the federal cabinet is what's called a public order emergency. And one of the legal conditions for declaring a public order emergency is that the existing laws of Canada not be sufficient to deal with the problem. And so what we did in our pleading and what we intend to argue in court is that police authorities at the municipal level and also provincial police have extensive powers under the criminal code and provincial offenses legislation. And there are many offenses that were violated by protesters. And between
these were, sorry to interrupt, Sujit, these were things that were dealt with at, for example, the Ambassador Bridge, using the ordinary powers. I want to follow up on this, but we've got to go to commercial break. We will be right back. Welcome back to Canadian Justice. We're discussing the federal government's invocation and later retraction of the Emergencies Act to deal with truck protests in Ottawa. Now, Sujit, in the last segment, we were talking about how the federal government, we say, could have used ordinary policing powers to deal with the protests in Ottawa. What were some of those powers that could have been used?
For example, so let's just back up and point out that not only were there existing powers available to the police, but these powers were used prior to the proclamation of the public order emergency to clear most of the protests and blockades in Canada, for example, at the Ambassador Bridge. And so the powers that were used, I think, fall into two categories. So the first is that there were injunctions issued by courts in relation to the Ottawa and Windsor protests, and it's a criminal code offense to then not obey an injunction. And I think that's Section 127 of the code. And so that was that injunction was enforced using code powers, for example, in Windsor. And the bridge was cleared. And then the other offense that was at play is the offense of a public mischief in relation to property. And it is a criminal code offense to interfere with the use of property, both private and public. And police are allowed to charge and arrest individuals who've breached that criminal code offense, and they did. And so, in fact, most of the disturbances or protests in Canada were dealt with under these existing powers.
Now, Jenny, one of the things the government has relied on in particular is they said that they needed this Emergencies Act in order to have the big rigs on that block in Ottawa, where at the end of this, there were these big rigs there in this small area. They needed the special power in order to remove those big rigs. But could those have been removed using ordinary police powers as well?
Yes, I mean, let's just think about it. You park your car somewhere where you're not supposed to. What happens? You get a parking ticket. The car stays there, you get another parking ticket and another one. And eventually a tow truck comes and removes your vehicle. And that kind of option was available to the police. They could have simply ticketed the vehicles and have them removed. And in fact, the criminal code actually makes it an offense for a person who is without a reasonable excuse, who doesn't assist a police officer in the execution of protecting the peace, makes it a criminal offense. So if a tow truck driver refused to remove a rig for whatever reason, he or she could be charged with a criminal offense for not doing so.
So what was interesting is that the government invoked the Emergencies Act here in this particular situation when Canada has never invoked it before, despite, we've survived terrorist attacks, 2 years of a pandemic, and it's never been used here. Sujit, what would be an example of, we say this was not an appropriate use of the Emergencies Act. What would be an example of when it would be appropriate for the federal government to use this extraordinary legislation?
So the first thing to keep in mind is that there's 4 different types of emergencies, right? There's public welfare, public order, international, and war emergencies. And so I think your question more narrowly is, what would be a public order emergency? And I think the answer is perhaps an apprehended insurrection, which threatened the overthrow of a democratically elected government in Canada. But even there, we need to ask if the existing tools available to government under federal and provincial law are sufficient. And I would think that, barring the most extreme circumstance, they probably are, because our police have been given extensive powers to deal with these sorts of issues. And the code criminalizes much of the conduct that was at play here.
And some of that existing legislation includes provincial emergencies legislation, which we have seen used throughout the pandemic. So Jenny, how does the Federal Emergencies Act differ from those provincial emergencies acts that have been used throughout the pandemic?
So the Provincial Emergencies Act have to do with individual provinces. Ontario would declare an emergency and it would affect Ontario alone, whereas the federal emergencies legislation affect Canada across the provinces and the territories. And so here, if this were truly an Ottawa problem, which the federal government seems to be saying that it was, the protests happening there, it is a question as to why weren't the provincial emergencies legislation enough? Like, why couldn't Premier Doug Ford have passed some sort of emergency legislation about blocking certain areas and making it illegal? And why wasn't that a sufficient route to take?
And Janani, we've only got about 20 seconds, but the federal government said that this emergencies invocation was limited to just Ottawa. Is that accurate?
It applied across Canada. It could have applied to the stuff that was taking place in Alberta. So no, I don't think it's fair to say that it was limited to Ottawa alone. And if it had been, then why invoke the Emergencies Act at all?
We've got to go to commercial break, but we will be right back. Welcome back to Canadian Justice, where we're discussing the federal government's invocation and retraction of the Emergencies Act. So, Sujit, what does Canada's history with emergencies legislation tell us about how these types of laws are used and why we should be so careful about them?
So the predecessor to the Emergencies Act was the War Measures Act, and the War Measures Act was actually a series of statutes that was in force in Canada from 1914 until that regime was replaced with the Emergencies Act in 1988. And the abuse of executive power by the federal cabinet under the War Measures Act was one of the darkest moments in Canadian history. So it was the War Measures Act that was the legal basis for the internment of Japanese Canadians during the Second World War. It was the War Measures Act that was the legal basis for the internment of Italian Canadians during the Second World War. And then it was also the War Measures Act that was the basis for the abuse of emergency powers by the Trudeau government under Prime Minister Pierre Trudeau in 1970 in the wake of the FLQ crisis. And in all those cases, when we look back at them after the moment of panic, we realized that governments had overreacted. They'd not taken the narrowest means necessary to address legitimate public policy goals. They had violated people's rights. They'd engaged in horrendous racial discrimination, and they'd used the powers for purposes that they were never intended to be used. So, for example, with respect to the FLQ crisis, these powers were used to attack union leaders, who had nothing to do with the threat in Quebec. And so, the Emergencies Act was drafted as a deliberate response to that dark legacy in very narrow terms. And it's incumbent upon the courts to interpret those terms strictly because of the history of the abuse of emergency powers in this country to ensure that those sorts of abuses never happen again.
So important that we learn from our history. Janani, one of the areas of the use of the Emergencies Act that really has struck a lot of people as overbroad were some of these financial measures, the freezing of accounts, the measures that allowed the government to disclose otherwise private banking information to the police. And the CCF is arguing that this is a charter infringement. So what can you tell me about that?
So Section 8 of the Charter of Rights and Freedoms guarantees that we have a right to unreasonable search and seizure. And banks have very intimate personal information about us, how we spend our money, how much money we have in our accounts. And what the emergencies legislation allows is for the economics regulation, what it allows for is for financial institutions to pass on these intimate information about us to the authorities, to FinTrack, to other different kinds of police powers. And, the charter guarantees that we should be free from unreasonable search and seizure. And here, there is no authorization that's required before the banks pass this information on. There's no guidance for what does one have to do in order for that information to be passed on. So it's a real concern that we have with the way that the regulations have been drafted.
And that disclosure would constitute a search. So one of the things there's been so much commentary on, Jenny, is that the Emergencies Act states at the beginning of it that it's subject to the Charter. So a lot of people, I've seen pundits say this, that what has happened isn't a violation of civil liberties because the Emergencies Act is subject to the Charter. So this analysis is all wrong, but briefly, can you explain what's wrong with it?
So every law in Canada is subject to the Charter, and it's not enough to just have a rubber stamp that says approved by the Charter as though it's some sort of approval that everything is going to be consistent with the Charter. Our role as lawyers in this litigation is to ensure that it's not just them saying it's subject to the Charter, but actually when you break it down, is it truly in accordance with the Charter, and is it going to pass the muster of the Constitution?
Yeah, I mean, if the rule was that every piece of legislation and every government action says it's charter compliant, if that made it charter compliant, we would never have a charter violation. We've got to go to commercial break in a second, but what I wanted to raise in the next segment is the issue that the Emergencies Act has been revoked. It was voted on in Parliament. It was confirmed, Emergencies Act, the emergency powers were confirmed by Parliament, but then 2 days later, the Prime Minister turned around and revoked the emergency. And I want to talk about what impact that is going to have on the case, and whether or not that shows that this might have been quite a politicized decision. We've got to go to break, but we'll be right back. Welcome back to Canadian Justice, where we're discussing the federal government's invocation of the Emergencies Act. So, Sujit, the declaration of emergency has now been revoked by the Prime Minister. The CCF, the Canadian Constitution Foundation, the charity I work for and that you're representing, they're still proceeding with the challenge. So what does this revocation mean for the case?
So the government is going to argue, we anticipate, that the case is moot. And what that technically means is that because the emergency proclamation has been rescinded and the measures therefore have expired, there is no live legal dispute between the CCF and the government. And we're going to argue that the court should exercise its discretion to hear the case, notwithstanding the fact that it might be moot, because it falls into a category of cases that are otherwise evasive of review. And what that means is that the cases involve measures or decisions that are short-term measures that are time limited and as a consequence are very likely to have expired by the time they're properly adjudicated by the courts, and certainly by the time they get up to a court of appeal or the Supreme Court. So there's other examples where the Canadian courts have said, well, we're going to hear a challenge to bail conditions, even though the duration for that bail has long passed, or a review board order, or et cetera, or a habeas corpus
Would this
petition.
type of argument have applied during the abortion cases, where a review would not happen until after the 9-month period?
Yeah. So for example, the classic example is Tremblay and Degla, where Ms. Tremblay was expecting a child. It was Ms. Degla was expecting a child, and her partner, or the father of the child, sought a court injunction to prevent her from terminating her pregnancy. And during the hearing, it was announced that she had gone to the United States and had had a legal abortion. And the court decided nonetheless to proceed with hearing the case and deciding it to provide guidance for the future. So that's yet perhaps a classic example.
Yeah, so the court can hear these cases even after the time-limited issue has expired. Jenny, can you tell us what the CCF is looking for in this case, especially now that the emergency declaration has ended? What would a win look like?
I think a win would look like asking the government these important questions about, was this truly an emergency? What information did you have to say that it was an emergency that necessitated this really extraordinary piece of legislation, and to create some tangible guidance for future governments when they're going to resort to the Emergencies Act. I think that's the important role that the CCF is going to play, is to carve out this guidance for future cases.
So, Sujit, the Prime Minister, we've got about a minute left. The Prime Minister revoked the emergency declaration 2 days after the vote, where he said it was really necessary. So what does that tell you about whether or not this was a political decision, or if the criteria of the act was actually met?
Well, it does place into serious question how serious the threat was to Canada's security. If 2 days after the measures were being debated and voted on in the House, and before they were voted upon at all by the Senate, the Prime Minister suddenly announced that the measures were no longer necessary and that existing law enforcement tools were necessary. And as Jenny said, we'll be able to answer that question once we are able to access the evidence that the government is legally required to put before the federal court. And specifically, we are interested in what materials were put before Cabinet when it made all those decisions, both to trigger the proclamation and to revoke it.
Well, I'm obviously very invested in the case. I'm really fascinated in it. I think that we can't normalize governing using emergency powers. So I want to thank you both so much for your hard work on this topic and in this matter.
Great. Thank you very much.
Yep. Thank you.
We've heard today about the CCF's challenge to the federal government's invocation of the Emergencies Act. This is a court battle I'm obviously invested in as the litigation director for the CCF. I firmly believe that the Prime Minister's use of this extraordinary legislation was politically motivated, and that we must push back against the politicization and normalization of emergency powers. But what do you think? Was the use of this special law to give government expansive powers to deal with a disruptive protest justified? You be the judge. Thanks for watching, and remember, a freer Canada starts with you.